With the coming into being of BSA, a common man as well as the lawyer and the judges are thinking as to whether there is a change under the provisions of the Evidence Act, or what are the corresponding sections, or they continue to remain the same. Therefore, to understand the Evidence Act, we had requested Justice V Ramkumar, a former judge of Kerala High Court, who is now well named for sharing his knowledge earlier through his judgments and now through his knowledge sharing process. Corroboration under Section 157 of the Evidence Act, viz. The corroboration to Section 160 of the BSA 2023 is today's session, and we are glad that Justice V Ramkumar accepts our invite. And we keep on receiving the messages to that effect that we should ask Sir to share his knowledge, and he has always been kind enough to share his knowledge despite his hectic schedule on writing various articles as well as sharing his knowledge on live law. Thank you on behalf of all our viewers, and we hope that you continue to maintain good health and you continue to share your knowledge. Over to you, sir.
Thank you, Mr. Vikas. Good evening, friends. The other day we have seen contradiction provable under Section 145 of the Evidence Act. Now today we have some in-depth study on corroboration under Section 157 of the Evidence Act, corresponding to Section 160 of the Bharatiya Sakshya Adhiniyam 2023 BSA. Now, the later testimony of a witness can be corroborated by recourse to Section 157 of the Evidence Act. They said Section 157, I will read the section. Former statements of witness may be proved to corroborate later testimony as to same fact. In order to corroborate the testimony of a witness, any former statement made by such witness relating to the same fact at or about the time when the fact took place, or before any authority legally competent to investigate the fact may be proved. Now, what do you mean by corroboration? The Black's Law Dictionary defines corroboration to mean confirmation or support by additional evidence or authority, formal confirmation or ratification, corroboration of a witness testimony. This is what the Black's Law Dictionary says. Now, corroboration is nothing other than evidence which confirms or supports or strengthens other evidence. It is, in short, evidence which renders other evidence more probable. The classic observation is by Lord Simon in Director of Public Prosecution versus Kilbourne, 1973, 1 All England Reports 440, House of Lords, by Lord Simon. That is, corroboration is nothing other than evidence which confirms or supports or strengthens other evidence. It is, in short, evidence which renders other evidence more probable. So, supporting evidence. While substantive evidence is evidence which can stand by itself, corroborative evidence cannot independently stand alone by itself. It can only support or strengthen other evidence. Now, Section 157 of the Evidence Act is an exception to the rule that a person cannot corroborate himself. I cannot corroborate myself. My earlier statement can be corroborated by somebody else, by the prosecution or somebody else. There's no point in myself saying I have stated so earlier. No. So the principle is, it's an exception to the rule that person cannot corroborate himself. This is a situation where he can even corroborate himself. This was a classic observation by a 3 judges bench of the Supreme Court in Gauranga Charan Mohanty versus State of Orissa, 1968 Supreme Court Digest 175. The observation is at page 181. The three judges are Judge Justice S.M. Sikri, Justice J.M. Shelat, the author, and Justice K.S. Hegde. Unfortunately, this particular decision is not available in any other law journal except the Supreme Court Digest. In fact, I made some frantic search through my friends in Delhi. No chance. Of course, those who have subscribed to Supreme Court Digest, they may be having the original text. I have not been able to lay my hands on the full text of the judgment. Section 157 of the Evidence Act envisages two categories of statements of witnesses which can be used for corroboration. As we read the section, first is the statement made by a witness to any person at or about the time when the fact took place. The second is the statement made by him to any authority legally bound to investigate the fact. If the statement is made to an authority competent to investigate the fact, such statement gains admissibility no matter whether it was made long after the incident. It need not be contemporaneous. It need not be simultaneous. But if the statement was made to a private person, it loses its probative value due to lapse of time. If the statement was made contemporaneous, with the occurrence, the statement has a greater value as a res gesture. That is, it is then substantiated. Supposing you are watching a murder taking place, or rather subjecting a victim of a murder makes a statement. Oh, John, you stabbed me. It's a simultaneous, spontaneous statement. That is a res gesture. But here it is not res gesture, but almost like a res gesture. And it is res gesture is substantive evidence, but not corroborative. But if it was made only after some time interval, the statement loses its probative utility as res gesture, but it is still usable under section 157 of the Evidence Act, though the user is for a lesser use. This was so observed by Justice K.T. Thomas in State of Tamil Nadu versus Suresh, AIR 1998 Supreme Court 1044. Now, what is the meaning of at or about the time when the first fact took place? What do you mean by at or about the time when the fact took place, occurring in section 157 of the Evidence Act? The Supreme Court has held that no hard and fast rule can be applied. The main test is whether the statement was made as early as can reasonably be expected and before there was opportunity of tutoring or concoction. See, when there is delay, when there is a time lag, there is a possibility of the witness being tutored or concocted. Some vested interest may intervene and they may try to color his views by adding their own views. So that is why this spontaneity is insisted. You may refer to Rameshwar versus State of Rajasthan, AIR 1952 Supreme Court 54, AIR 1952 Supreme Court page 54. The author of the judgment is the great Vivian Bose. Held that the statement by in that case, it was held that the statement by the 80-year-old rape victim to her mother about the occurrence of rape after 4 hours, which was explained also, that delay was also explained, amounted to corroboration from independent sources. The statement to the mother and the mother's testimony was held to be independent source, though it is the mother giving the evidence. Now, should not the former statement of a witness be in writing or reduced to writing? While discussing contradiction, we saw that for proving a contradiction, there should be a statement in writing, reduced to writing, or a written statement. Now, for a corroboration, no such requirement. It can even be oral. In Bhagwan Singh versus State of Punjab, AR 1952 Supreme Court 214, Justice Vivian Bose again, there is an illustration given. The learned judges have tried to illustrate the principle. Witness stated in chief examination during while he was deposing, I saw the accused shoot X. In cross-examination, he resiled and stated, I did not see it at all. The witness was then asked, didn't you tell A, B, and C on the spot that you had seen the accused shoot X? Witness replies, yes, I did. Here, the oral admission by the witness that he told A, B, and C of having seen the accused shoot X is a clear case of corroboration. That was not written, not reduced to writing. It was an oral statement. So beautifully illustrated by Justice Vivian Bose. Here the statement of the witness to A, B, and C was not reduced to writing, and it was not made to the police or magistrate authority, the person in authority. But the former statement of the witness cannot be used as substantive evidence. It can be used only as a corroborating piece under section 157 of the Evidence Act. The testimony of the witness given in chief examination or can be used to shake the credit of the witness or to test his veracity under section 146 of the Evidence Act. There is no application of section 145 of the Evidence Act which insists on a statement in writing or statement reduced to writing. So therefore, that is the main distinction between 145 of the Evidence Act and 157 of the Evidence Act. Now, in such a case, resort to 145 would be necessary only if the witness denies that he made a former statement. If the witness denies having given a former statement, then you can cross-examine him with reference to 145. But the rider being, there should be a statement in writing or reduced to writing. This was highlighted by Bhagwan Singh versus State of Punjab, AR 1952, Supreme Court 214. Again by the great Justice Vivian Bose. Now, what is the use to which an FIR, first information report, can be put to? An FIR can only be used as a previous statement for the purpose of either corroborating its maker under section 157 of the Evidence Act or for contradicting him under section 145 of the Evidence Act. It cannot be used for the purpose of corroborating or contradicting any other witness. Only the maker of the statement can be contradicted or corroborated. Sheikh Hasib versus State of Bihar, AIR 1972, Supreme Court 283, 3 judges verdict. The author of the judgment is by I.D. Dua, Justice I.D. Dua. Again, Shankar versus State of UP, AIR 1975, Supreme Court 757. Justice V. R. Krishnaiyer and R. S. Sarkaria. Justice R. S. Sarkaria is the author of the judgment. There is one more decision. Babu Singh versus State of Punjab, AIR 1996, Supreme Court 3250. G.B. Patanaik is the author of the judgment. Then, again, with regard to section 154, FIR. Section 154 of the Code of Criminal Procedure provides for the recording of the first information by the maker. The information report as such is not substantive evidence. FIR as such is not a substantive evidence. It may be used to corroborate the informant under section 157 of the Evidence Act or to contradict him under section 145 of the Evidence Act. If the informant is provided, the informant is called as a witness before court. Then his previous statement in the form of first information report can be used for corroborating him or for contradicting him. Since it is a written statement in writing, 145 also can be used for contradicting him. If the first information of an inculpatory nature is given by an accused himself, the fact of his giving the information is admissible against him as evidence of his conduct under section 8 of the Evidence Act. If the information is non-confessional, non-inculpatory, it is admissible against the accused as an admission under section 21 of the Evidence Act and is relevant. Faddi versus State of Madhya Pradesh, AIR 1964, Supreme Court, 1850. Raghubar Dayal, the author of the judgment. Learned Judge was explaining an earlier verdict in Nisar Ali versus State of UP, AIR 1957, Supreme Court, 366, a 3 judges bench. Then the earlier Privy Council decision, Dal Singh versus King Emperor, AIR 1917, Privy Council 25, by Viscount Haldane, judge. But a confessional first information report to a police officer cannot be used against the accused. Why? A confessional first information report cannot be used against the accused. If the accused himself is giving the confessional FIR, not a non-confessional, confessional, inculpatory FIR, it cannot be used against him because by virtue of Section 25 of the Evidence Act. Is it not? Section confession made to a police officer cannot be used because of the interdict under Section 25 of the Evidence Act. You may refer to Agnu Nagesia versus State of Bihar, AIR 1966, Supreme Court 119, 3 judges decision. K. Subbarao, Raghubar Dayal, and R.S. Bachawat. R.S. Bachawat being the author of the judgment. Then again, FIR can be used for corroborating the maker, provided the FIR has been duly admitted in evidence in accordance with the Evidence Act. Otherwise, the FIR cannot be used for corroborating the evidence of the maker. It has to be duly admitted as per the Evidence Act, provisions of the Evidence Act. Damodar Prasad, Chandrika Prasad versus State of Maharashtra, AIR 1972, Supreme Court 622, by Justice A.N. Ray, the author of the judgment. Now, in the above decision, the Supreme Court observed the use of an FIR for the following purposes. 1. The first information report is not substantive evidence. It cannot be relied upon when it is not tendered in evidence in accordance with the Evidence Act. When the first informant was examined, thereby denying the accused an opportunity to cross-examine the first informant on the FIR. See, first informant was examined, but the FIR was not duly proved according to the Evidence Act. In that case, his statement cannot be used for corroboration because the accused was denied an opportunity to cross-examine him. Second principle was, FIR can be used for one of the limited purposes of corroborating or contradicting only the maker of the FIR, only the author of the FIR, not anybody else. Third principle was, another purpose for which the first information report can be used is to show the implication of the accused to be not an afterthought. See, it is promptly, FIR is expected to be given promptly without any time lag. So it shows that the accused was not falsely implicated as an afterthought. For that purpose also FIR can be used. The last use is FIR, first information report, can be used under Section 32(1) of the Evidence Act as to the cause of the person's death or as part of the informant's conduct under Section 8 of the Evidence Act. The informant's conduct or the cause of his death falling under Section 32(1) of the Evidence Act as a dying declaration. Therefore, these are the 4 uses of first information statement. Then the testimony of first informant before court regarding in yet another case, Supreme Court said, the testimony of the first informant before court regarding the participation of the accused in the occurrence was held to be corroborated by his earlier statement in the form of an FIR in which the names of the accused and the names of eyewitnesses were mentioned. So the FIR was used for corroborating his statement in court regarding the names of the accused and the names of the witnesses who were present at the spot. Dargahi versus State of UP, AIR 1973, Supreme Court 2695, by the great H.R. Khanna, judgment by Justice H.R. Khanna. Then, yet another statement which can be used for contradiction as well as corroboration is the statement of a witness recorded by a magistrate under section 164 CRPC. See, as you know, under section 164 CRPC, a magistrate can record the confession of an accused without he being sponsored by the police, and also the statement of a witness or victim sponsored by the police. Now, in the case of statement of a witness under section 164 CRPC, that statement, when that witness is examined before court, it can be used for contradicting him as well as corroborating him. Contradicting him under section 145 of the Evidence Act and corroborating him under section 157 of the Evidence Act. Ram Kishan Singh versus Harmeet Kaur. Ram Kishan Singh versus Harmeet Kaur. AR 1972 Supreme Court 468. Judges are A.N. Ray and Justice D.G. Palekar. Justice A.N. Ray being the author of the judgment. Again, Chandrasekharan versus State of Kerala. 1993, this is a Kerala decision. 1993, 1 KLT 571 by Justice K.T. Thomas, the author of the judgment, and K.K. Usha. K.T. Thomas being the author. Again, Baijanath Shah versus State of Bihar. 2010 Criminal Law Journal 3821 corresponding to 2010 volume 6 SCC 736 Harjit Singh Bedi and C.K. Prasad. They are the co-authors of the verdict. Now, use of confessional soliloquy as corroborative evidence. What do you mean by soliloquy? Confessional soliloquy. Confessional soliloquy are mutterings of a confused mind. It may be an expression of conflict of emotion, a conscious effort to stifle the pricked conscience. It is an argument to find excuse or justification for his act. It is a penitent or remorseful act of exaggeration of his part in the crime. The tone may be soft and low. The words may be confused. They may be capable of conflicting interpretations depending on the witnesses, whether they are biased or honest, intelligent or ignorant, imaginative or prosaic, as the case may be. Before such evidence of confessional soliloquy is accepted, it must be established by cogent evidence as to what were the exact words used by the accused. We have seen this expression, exact words used by the accused. We call it, we use the Latin maxim, ipsissima verba. The exact words used by the accused are to be stated by the witness. Even if the evidence of confessional soliloquy has been found admissible, prudence and justice demand that such evidence cannot be made the sole ground of conviction. It cannot be the sole basis for a conviction. It has to be corroborated by some other evidence also. Because after all, you are trying to convict him for his offense on his own soliloquy. Now, the beautiful observations were made by Justice K. Subbarao in a 3-judges verdict in Sahu versus State of UP, AIR 1966, Supreme Court, page 40. Now, I will give an example of a confessional soliloquy. A witness testified before court that in the night after the occurrence, he heard the accused muttering to himself, he, the deceased, was a traitor. He did not deserve to live. I was doing justice by finishing him off. He is going on muttering to himself. He was a despicable person who did not deserve to live. Therefore, I was doing justice by finishing him off. Supposing a witness happened to overhear this, this is a clear case of confessional soliloquy. If these exact words of the accused are to be deposed before court, the court can convict him, of course, as a safe guide of prudence. Court may insist on corroboration also from other sources. Now the statement of prosecution witnesses examined under sections 200 and 202 CRPC, that is the sworn statement when a private complaint is filed. Those statements can be used under section 157 of the Evidence Act for corroborating their evidence when examined during trial. This was held by a constitutional bench of the Supreme Court in Hardeep Singh versus State of Punjab. AR 2014 Supreme Court 1400 corresponding to 2014 3 SCC 92. 5 judges. Author of the judgment is Justice Dr. B.S. Chauhan. There were Justice P. Sadashivam, Chief Justice of India, Ranjana Prakash Desai, Ranjan Gogoi, and S.A. Bobade, besides Justice Dr. Justice B.S. Chauhan. Now, the statement of prosecution witnesses recorded during an inquiry under section 202 CRPC cannot be used under section 157 of the Evidence Act for corroborating the evidence of other witnesses, whether it is 202 or any statement, whether it is 160 or 200 or 202 CRPC. Their statement can be used for corroborating the maker, not any other witness. It was Shashi Jena versus Kadal Swain, AIR 2004 Supreme Court 1492. Justice Y.K. Sabharwal and B.N. Agrawal. Justice B.N. Agrawal is the author of the judgment. In one case, the testimony of PW12, the brother of the deceased, who had accompanied the deceased when the latter was attacked by the accused, was to the effect that he had narrated the whole incident to PW5, who came there on hearing gunshots. The PW12, the witness, was accompanying the victim to a particular place. When they reached a particular place, the victim was attacked. Then, hearing by a gunshot injury, hearing the gunshot, PW5 in that case came running. Then PW12 told him what happened, we saw, told him what happened. This evidence of PW5, that PW12 narrated to him the occurrence, was held to be a clear case of corroboration. His statement of PW5 was amply corroborated by the testimony of PW12, who also stated that he had told the occurrence about the occurrence to PW5. You may refer to Rameshwar Yadav, Ramshray Yadav versus State of Bihar, AIR 2006 Supreme Court 201, AIR 2006 Supreme Court 201. Judges are H.K. Sema and G.P. Mathur, G.P. Mathur being the author of the judgment. Now, lastly, the evidentiary value of a witness to a Panjanama. A Panjanama can be used as corroborative evidence under section 157 of the Evidence Act. When a Panj witness gives evidence in court, such a witness can also use the Panjanama for refreshing a witness to a Panjanama. Supposing there was a seizure, recovery, and it's a Panjanama prepared. A witness, an independent witness who had witnessed the seizure can be an attester to that Panjanama. If he is giving evidence, his statement can be corroborated with reference to the recitals in the Panjanama. And he can also refresh his memory using the, by virtue of section 159 of the Evidence Act, by referring to the recitals in the Panjanama. This was held so in Yaqub Abdul Razak Memon versus State of Maharashtra. 2013, volume 13 SCC, page 1. The relevant paragraph is obtained at, it's a very long judgment. Para 354 of Yaqub Abdul Razak Memon versus State of Maharashtra. 2013 SCC 1. Justice Sadashivam is the author. Dr. Justice B.R. Chauhan. B.R. Chauhan is also a co-author. With that, we have finished corroboration. The other day we dealt with contradiction under section 145. Today we have discussed corroboration under section 157 of the Evidence Act. Yes, friends, Mr. Vikas. We have come to a close on section 157, corroboration.
Just I'm checking it out. One person is asking, sir, kindly give the name of the parties of 1968 Supreme Court.
68 Supreme Court.
Which you have said, Digest 175.
You mean earlier?
Pardon?
Is it 68 or 66? I said 66 Supreme Court.
Just checking out. It has been written 68. You can give the 66 citation.
66 citation is Agnu Nagesha versus State of Bihar. A year 1966, Supreme Court 119.
Yeah. And okay. Another is saying, could you share the judgments which you have referred? If that is convenient, we can share it on the website.
Oh yes. Oh yes.
Thank you, sir. Thank you.
Yes.
Thank you for sharing your knowledge. And we
you mean there's one decision of Tamil Nadu. You mean that Justice Thomas, he is referring to Justice Thomas' verdict, a year 1998 Supreme Court, is it not? Or 68?
She has written 68. Maybe
No,
there's
it's 98 Supreme Court 1044. State of Tamil Nadu versus Suresh. The judgment by Justice K.T. Thomas. Parties are State of Tamil Nadu versus Suresh. K.T. Thomas. 68? Then you mean I mentioned about a 68 decision which is not reported in any other journal.
Yes, sir.
That is Gauranga Charan Mohanty. Gauranga Charan Mohanty versus State of Orissa. 1968 Supreme Court Digest SCD 175 at page 181. The relevant judgment starts at 175. The relevant observation is at 181. That is an exception to the rule that a person cannot corroborate himself. Unfortunately, I checked up with the SEC, Criminal Law Journal, all other journals. They have not reported it. Only those who have subscribed to SCD, I think it died a natural death. SCD is no more there. It is not. I am told that it is not there even in SCR. SCR is the official reporter of the Supreme Court.
So sometimes nowadays we get it on the whilst we do this search, we get it on the advocate's coach or some other options.
Okay.
Yes.
Somebody, if anybody succeeds in getting the corresponding citation, I want the full text. I could not read the full text of the judgment. If anybody can get the full text, I will be very, very much grateful to you.
Yes.
Gauranga Charan Mohanty versus State of Orissa. 1968 SCD, page 175. 3 judges. Very, very strange. A 3 judges verdict is not reported in many of the popular law journals.
So just tell the citation. I will check it out. If I get it, I will WhatsApp you.
Gauranga, Gauranga, Gauranga Charan Mohanty versus State of Orissa. 1968 SCD 175. 3 judges. Justice S.160.
SCD, D for Delhi.
Supreme Court, yes, D for Delhi. Supreme Court Digest. Must be Supreme Court Digest.
Okay.
And I don't think it is currently available. They have stopped it.
Okay. I'll just check it out and I will revert you after this.
The author of the judgment is James Shelar. Justice James Shelar. Other 2 judges are S.160 and K.S. Hegde. Such a 3 judges verdict is not reported by any of the popular law journals. Very strange.
After the session, immediately I'm checking it out.
Okay, thank you.
Thank you, sir. Thank you for sharing your knowledge.
Welcome.